Good day, class. This is attorney season, and welcome again to Criminal Law 1. Today, I'll be discussing Articles 7 to 10 of the Revised Penal Code. So let's start. Article 7 of the Revised Penal Code. So when light felonies are punishable. So under Article 7 of the Revised Penal Code, light felonies are punishable only when they have been consummated, and with the exception of those committed against person or property. Remember, the general rule is that light felonies are punishable only when they have been consummated. That's the general rule. Exception are those felonies committed against person or property. Example of crimes against persons, mga physical injuries or crimes against property like theft. Okay, so that's the exception. So mapunish ang attempted theft of attempted slight physical injuries, if ever, because it's an exception. Even if light felonies lang na sila, it falls under the exception of Article 7, therefore punishable even if in the attempted stage. So examples of light felonies, we have slight physical injuries. Okay, so slight physical injuries under Article 266. So if nakaigikulata, okay, and nag-require og medical attention na from 1 to 9 days, so that's slight physical injuries. If nag-require siya medical attention of 10 to 30 days, that's less serious physical injuries. And if nag-require siya medical attention of more than 30 days, that's serious physical injuries. So 1 to 9 days medical attention, slight physical injuries. 10 to 30 days, that's less serious. And if more than 30 days, that's serious physical injuries. Then theft, okay? Simple taking. Okay, I'm not saying it's simple, but it's the taking of personal property belonging to another. Okay, as long as it will fall under paragraph 7 and 8 of the Revised Penal Code. However, punishable na because this is an exemption. Crimes against property. Theft is a crime against property. Therefore, punishable ang attempted stage. Alteration of boundary marks. So if ang muhon, imong irugon, parang budako-dako, imong area. Okay, that's alteration of boundary marks. Malicious mischief. So if ever you will willfully destroy the property of another, like imong gubon ang cellphone sa imong classmate, imong gubon ang kural sa imong silingan. Okay, that's malicious mischief. Okay, and you are liable if ever you will willfully destroy the property of another. And intriguing against honor. Of course, intriguing against honor. If you will blemish the honor and the reputation of a person, you will suffer, or you will be held liable for intriguing against honor under Article 364 of the Revised Penal Code. As a rule, light felonies are punishable only when they are on their consummated stage, always on the consummated stage. So this is the general rule. However, not an exception. So exception is unless the crime is committed against person or property. Okay, mo na siya exception. Why are attempted and frustrated felonies not punishable? Because of course, light felonies produces light, insignificant moral and material injuries. Okay, and if they are not consummated, the wrong done is so slight. Okay, to the point that there is no need anymore of providing a penalty. Okay, so dapat always consummated. That's the general rule. What is the reason for the exception katong crimes against person and property? Because of moral depravity. Okay, So mas grabe magud pag crimes against person and property because it affects uh, the person of the victim, okay, and his property. Okay, so there's moral depravity. Article 8, conspiracy and proposal to commit felony. So under Article 8, conspiracy and proposal to commit a felony. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefore. And what is conspiracy? A conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. And there is proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. So in conspiracy, let's just say, si A and si B nagkasabot nga i-rob ang bank, okay, tomorrow. And then they decided to commit it. So there's conspiracy between them. And an apple of one is an apple. In proposal, let's just say, si Mr. A naka-decide nga i-rob ang bank tomorrow. Then iyan gi-propose na ni Mr. B para siya may rob sa bank, not Mr. A. Okay? And then isugot si Mr. B. So that's proposal. Okay? So a person who has decided to commit a felony proposes its execution to some other person. So dili siya yung magbuhat but katong iyang gi-proposan. Okay? So difference between conspiracy and proposal. So in conspiracy, it's a bilateral act. Okay, so two persons are involved here, and the two persons agreed to the commission of the crime. In proposal, it's a unilateral act. Only one person decided to commit the felony. Okay, then iyarang gi-propose, okay, to some other persons to commit the crime. So that's proposal. General rule, not punishable as an act. Okay, so conspiracy and proposal are not punishable as an act. Okay? So if magsabot ta diri nga mag-rob tag bangko or atong ripon ang basta ka tawo, dili ta liable because nulong krimen, nulo pwena sa nilahi. There is no crime and there is no law punishing it. Wala man tay law nga nagpunish nga mag-agree ra ta nga mo-commit og crime. Like o nga magsabot ta nga mo-commit og rape or mo-commit og robbery, mo-commit og homicide. Okay? So it's not yet punishable kay wala mo tay overt acts sing gibuhat. However, not the exception unless the law specially provides for their penalty. Okay? So muna siya exception. If the revised penal code provides that conspiracy to commit homicide is punishable, then you are liable. And one good example, aning exception is conspiracy to commit treason or conspiracy and proposal to commit treason. It's punishable under the revised penal code. So that's a good example for the exception. So as long as mag-provide siya penalty, so mere conspiracy and proposal are punishable under the revised penal code. So if conspiracy or proposal to commit a crime are provided in penalties by law, it is not necessary that there be an overt act committed. Okay, no overt act is needed as long as no conspiracy. So the mere act of conspiring and proposing will already give rise to a crime. So the following are conspiracies as a crime. So under the revised penal code, muna sila conspiracy to commit treason, conspiracy to commit rebellion, conspiracy to commit sedition, and under special penal laws, katong conspiracy to commit terrorism. So if ever, okay, imo ni makomit, mag-conspire mo about committing treason, rebellion, sedition, and terrorism, you'll be held liable. Okay, because it falls under the exception. And in conspiracy to commit treason, rebellion, sedition, terrorism, it is not necessary that there be overt acts. They are punishable acts by themselves. Okay, again, punishable siya as long as there's conspiracy. So example, A, B, C, D, and E come to an agreement to take up arms and overthrow the government and steer public uprising. So this is rebellion. So they already bought guns and pieces of equipment. However, before they could execute their plan, they were apprehended. Now, are A, B, C, D, and E criminally liable even if wala pa'y overt acts, wala pa na nakumit ang crime nga rebellion? So the answer is yes. They were liable for the crime of conspiracy to commit rebellion. Even though they were not able to execute their plan, conspiring to overthrow the government is already a felony, which makes them criminally liable. Okay? So another example, A, B, C, D, and E come to an agreement to kidnap X, kidnap, and thereafter exchange him for ransom. However, before they could execute their plan, all of them were arrested on that time. Now, did A, B, C, D, and E incur criminal liability? The answer is no, because there is no crime of conspiracy to commit kidnapping for ransom. Again, nullum crimen nulla pena sine lege. There is no crime if there is no law punishing it. Okay? So A, B, C, D, and E did not incur criminal liability. So overt act in furtherance of the conspiracy. So overt act in furtherance of the conspiracy, we have active participation in the crime itself. So if nagsabot mo nga i-rob ang usa ka balay nya puro mo ni participate, so that's an active participation in the crime itself. Then lending moral assistance to his co-conspirators by being present at the commission of the crime, maybe as a lookout. Okay? So that's an overt act in furtherance of conspiracy. Then exerting moral ascendancy on the other co-conspirators, manugo, okay, kuan ang mga butanga, mahalo na, etc. Matinda na to kuan. So exerting moral ascendancy on other co-conspirators. Conspiracy as a means of committing a crime. So if conspiracy is only a means of committing a crime, it is not yet a punishable act. The mere act of conspiring will make the offenders co-conspirators, but they are not yet punishable. They are not yet criminally liable because there's no overt acts yet. Okay? And there are two kinds of conspiracy as a means of committing a crime. We have direct or express conspiracy and implied or inferred conspiracy. There is direct or express conspiracy when the offenders or conspirators met, planned, and agreed and decided to commit the crime. So nagsabot si A, B, and C nga morab og bank, and then nagkita sila ilang planuhan. Nag-agree sila nga muna yung mga pangbuhaton, and then ilang gi-commit ang crime. Okay? So there's direct or express conspiracy. There is a preconceived plan prior to the commission of the crime. Kaya nagsabot lagi. Ano sila yung prior agreement or preconceived plan. So for one to be criminally liable of direct or express conspiracy, the following elements must be present. Number one, very important, there is prior agreement. Nagkasabot sila or preconceived plan. And presence at the time of the commission of the crime, naa sila during the commission of the crime. Si A, B, and C dapat naa sila during the commission of the crime. And even if he is part of the agreement, if at the time the commission of the crime he failed to appear, such failure on his part to appear at the scene of the crime would be construed by law as a desistance. Therefore, even if he is part of the agreement, he will not be liable as a conspirator. So for example, A, B, C, D nag-agree to commit the crime. However, during commission of the crime, absent si D. And because of this absence, it is construed by law as a desistance, meaning dili siya liable as a co-conspirator because wala siya ni padayon. Katurang si A, B, and C. Again, second element, presence at at the time of the commission of the crime. If absent, it will be construed as desistance by law. And katong absent is not liable as a co-conspirator. Example, A, B, and C decided to kill X on a particular date and time. On the said date and time, A and B arrived and killed X. However, C failed to appear. Is C liable for the death of X? The answer is no. Although C was part of the agreement, he cannot be held criminally liable as a conspirator for the crime of murder because he failed to appear at the scene of the crime. And his failure to appear is construed by law as desistance. Okay? So I hope we are clear on this. Same problem, but all were present. A and B were about to kill X, but C performed acts preventing A and B from committing the crime. So we prevent C A and B from committing the crime. No question, is C criminally liable as a conspirator for the crime of murder? The answer is no, because C performed acts trying to prevent A and B from committing the crime. He cannot be held criminally liable as a conspirator for the crime of murder in the said case. Why? Iyamangi prevent si A and B from committing a crime. Okay? Even if present siya niya, hindi prevent, he will not be held liable. General rule, conspirators are liable only for the crime agreed upon. They are not liable for any crime which is not agreed upon. Okay? If nagsabot mo nga mang rob ra o sa kabalay, liable ra mo ana. Okay? Liable mo tanan sa robbery. Okay? If mang-rape ng imong kauban diha nga wala ka kabalo, etc., dili nakalabot anak na crime. If katurang crime nga inyong gi-agree, if mga rob mo, rob ra jud inyong liability, robbery yung liability. Exceptions, when the other crime was committed in the presence of the other conspirators and they did not perform acts to prevent its commission. For example, si A, B, and C nag-rob og usa ka balay. Okay, done na. And then, si C, iyang gi-rape ang bayi na tag-iya sa balay. However, si A and B, katanaw ra, wala niya gi-prevent nga si C from raping D, the homeowner. Okay, therefore, liable siya because it falls under the exception when the other crime was committed in the presence of other conspirators. So, if ever magaling ani, robbery, dapat i-prevent nimo imong co-conspirator. Otherwise, bisan pag wala ka ng rape dira, nagtanaw ra ka, liable gyapon ka. Okay? Because wala man ka ni perform og acts that will prevent the crime of rape from happening. Exceptions again, when the other crime committed was the natural consequence of the crime agreed upon. As you say, during robbery, na napatay. Okay? Yung malupyo, so that's robbery with homicide. Okay, so it's a natural consequence of the crime. Okay, you are armed during planning. And nagun mo dalang mga kutsilyo, mga weapons, okay, in order for the crime of robbery to be consummated. Therefore, as a consequence, usually naging mga matay anak, if ever. So, as a consequence, liable mo for robbery with homicide, if ever name matay. When the resulting crime is a composite crime or a special complex crime, or a single indivisible complex crime, like robbery with homicide. Okay? So that's a special complex crime. Ano yung mga exceptions to the general rule? Okay, example, A, B, and C decided to kill X. Went to the place where X will be passing at nighttime. When they saw X, A, B, and C surrounded X, and they all stabbed X. When X was lying on the ground, A and B left. C remained and took the valuables of X, like let's just say cell phone or wallet. What is or are the criminal liabilities of A, B, and C? So A, B, and C are all liable for the crime of murder as conspirators because it is the crime agreed upon. Again, they decided to kill X, B. So they are all liable for the crime of murder. However, only C will be liable for the crime of theft. Okay? Only C lang. Because A and B cannot be held liable for the crime of theft. Because the theft was not a crime agreed upon by all of them. And gi-commit ng crime of theft without A and B. Okay? Again, paghawa na ni A and B, usa si C nangawat. Okay? Sa mga valuables na X. So wala chance si A and B to prevent C from committing theft. Okay? And moreover, theft was committed in the absence of A and B. There was no opportunity for A and B to stop C in theft. Therefore, only C will be held liable for theft as a separate crime. Okay? Now we have here implied or inferred conspiracy. So implied conspiracy is deduced from the mode and manner of committing the crime. There is no preconceived plan, but the offenders acted simultaneously in a synchronized and coordinated manner, their acts of complementing one another towards a common criminal objective or design. It may happen that the conspirators do not know each other, since the offenders acted in a synchronized and coordinated manner. A conspiracy was established instantly, impulsively, at the spur of the moment. Okay, muna siya a good example. X was trying to stab Y. Y evaded all the blows. Z saw X was having a hard time stabbing Y. Z was an enemy of Y. So Z went at the back of Y and held both hands of Y at the back and told X to stab Y, which X did. Now, was there conspiracy between Z and X? Of course, yes, there's an implied conspiracy. Okay, and an implied conspiracy was established instantly, impulsively, at the spur of the moment. Remember that. Okay, there was no preconceived plan, wala sila kasabot. But the act of Z of holding the hands of Y is a direct and positive overt act, showing that he has the same criminal design. So parehas sila criminal design that of X, which is to kill Y. So pareha na sila criminal design to kill the victim Y. Okay? So that's an implied conspiracy. In case of implied conspiracy, for one to be considered as a conspirator, it is necessary that the offender have an active participation in the commission of the crime. Okay, dapat na active participation. Just like in the example given, katong patyon ni A, patyon ni A si B, and then maglisod siya patay ni B. So si C nga natoy grudge ni B, iyang gunitan si B, and then iyang pasulay og stab si A ni B. Okay? So, dapat ay active participation and mere presence at the scene of the crime, mere approval, mere acquiescence, mere knowledge of the commission of the crime will not make one a conspirator absent any active participation. Again, dapat na active participation. Dapat na ay buhaton. Okay? If wala, then no crime is committed. Because the basis is on the acts performed by the offender. Okay, so unlike a preconceived plan, there was a prior agreement. Therefore, mere presence or exercise of moral tendency will make will make one a conspirator. And in implied conspiracy, the conspiracy is established based on acts performed. Okay? So mere presence of the scene of crime, gatanaw ra ng tao, there's no conspiracy there. Dapat na active participation. Therefore, if you do not perform an act, if you are merely present, then you cannot be held a conspirator. So X was trying to stab Y. When Z saw X was stabbing Y, he shouted, "Sige, tirahin mo pa sa kaliwa, sa kanan." X kept stabbing Y. Was there conspiracy between Z and X? The answer is no, because there's absence of active participation. Again, mere approval, mere acquiescence, mere knowledge of the commission of the crime will not make one a conspirator. In case of implied or conspiracy, dapat na yung active participation. Penalty between conspirators. So when conspiracy is established, whether direct or express, implied or inferred, the act of one is the act of all. Again, in conspiracy, the act of one is the act of one. Therefore, all the perpetrators in the crime will have one and the same penalty. So same lang mo penalty if there's conspiracy. Okay? So equal mo o penalty na ma-receive. So same penalty will be imposed regardless of the quantity and quality of the participation. And the moment conspiracy is established, it is immaterial to determine who inflicted because all of them will have the same penalty. Okay? If, however, conspiracy is not established because of implied or inferred conspiracy, the penalty will be individual na. Okay? As long as maglisod o prove ang prosecution nga there's conspiracy. So, individual ang penalty. Magdepend na sa nature uh, of the act of the offenders. Okay? Nature of the act performed by the offenders. Conspiracy and special penal laws. So conspiracy may be appreciated in special penal laws if the law specifically provides therein. Okay, if wala nag-provide ang law, then of course dili ma-appreciate ang conspiracy in special penal laws. So example, Murillo versus People. So Mayor Mitra was traversing a road in his Tarex when he encountered a checkpoint. He was allowed to pass without undergoing a checkpoint. Mayor Mitra was followed by an ambulance driven by Murillo. Murillo was flagged down in the checkpoint, and upon inspection, bags of shabu were found in his possession. Murillo said he is with the mayor. The police officers then pursued the vehicle of Mayor Mitra, and upon inspection, bags of shabu were found in the Starix. Was there conspiracy between Mayor Mitra and Murillo? Answer is yes. The Supreme Court held that the accused Mitra and Murillo committed the crime of transportation of illegal substance through conspiracy. Murillo himself admitted that he was with Mayor Mitra. This admission was enough to establish conspiracy between them. Okay, so this is a case of a violation of RA 9165, the Comprehensive and Dangerous Drugs Act of 2002. Okay, so applicable ang conspiracy pag RA sa mga RA 9165. And also applicable po ang conspiracy under Republic Act 9262, BAUSI, Violence Against Women and their Children. So Sharika and Steven were lawfully married. However, during their marriage, Sharika filed a temporary protection order or TPO against Steven and her in-laws. She argued that Stephen and her in-laws were acting in conspiracy in causing her physical and psychological abuse in violation of RA 9262, known as the BAUSI, okay, Violence Against Women and Their Children Act. The in-laws argued that they are not the proper party to the case because RA 9262 is filed only against the husband, boyfriend, or intimate partner of the woman. So the question is, whether or not RA 9262 may be filed against the in-laws. The answer is yes. RA 9262 allows suppletory application of the RPC. Hence, the laws may likewise be charged. The in-laws may likewise be charged of violation of RA 9262 if they acted in conspiracy with the husband, okay, or the man. So applicable ang conspiracy under Republic Act 9262. Because RA 9262 allows suppletory application of the RPC. We have here grave felonies, that's grave felonies, and light felonies. Article 9, grave felonies, that's grave felonies, and light felonies. So what are grave felonies? So grave felonies are those which the law attaches capital punishment for penalties which and any of their periods are afflictive, mga afflictive. So that's grave felonies, like mga rape, murder. Okay, in accordance with Article 25 of the Washington Code. And when we say less grave felonies are those usually punishes with penalties which in their maximum period are correctional, mga correctional. Okay, in accordance with the above mentioned article. Article 25. So example of capital punishment is death. Okay, that's a good example of a capital punishment. Afflictive penalties for grave felonies. Examples is reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prison minor. For less grave felonies, ito ning mga prison correctional, arresto mayor, suspension, and destierro. And then for light felonies are those infractions of law for the commission of which a penalty of arresto minor or public censure or a fine not exceeding 40,000 pesos or both. Okay, so that's light felonies. So grave felonies, lesser felonies, and light felonies. Very important. Offenses not subject to the provisions of this code, Article 10. So offenses which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary only to such laws. Okay, unless the latter or unless the special law should specially provide the contrary. Okay, so this code shall be supplementary only to such laws. Okay, so example for one. What if a person convicted of a violation of a special penal law? So A issued a check to B for payment of an obligation. B deposited, but the check bounced. Notice of dishonor was sent. After the trial on the merits, he was found guilty of the violation of BP 22 beyond reasonable doubt. Fine and payment of the value of the check. The court said in case of non-payment of the fine, the said convict shall suffer what? Subsidiary penalty under the revised penal code. And BP 22 is a special law. Bouncing check, this is anti-bouncing check law, BP 22. No question. Can a person who violated a special penal law like BP 22 and was imposed with fine be made to suffer subsidiary imprisonment in case of non-payment of fine? Because subsidiary imprisonment can be found in the revised penal code. Okay? The answer is yes. There is no provision in BP 22 prohibiting the application of the RPC. Then the RPC shall apply supplementary lang or supplementarily to the provisions of the special penal law or BP 22 unless the special penal law provides otherwise. So wala may provision sa BP 22 na prohibit sa pag-apply sa RPC. Therefore, the RPC can apply its provisions supplementarily to the provisions of BP 22. So, pwede ang subsidiary imprisonment. Examples of unless. So, Section 98 of RA 9165, Drugs na yan, Dangerous Drugs Act, Comprehensive Dangerous Drugs Act of 2002. It is expressly provided that the provisions of the RPC shall not apply to violations of RA 9165. The law uses the word shall. What's the exception? If the offender is a minor, in that case, if the minor is penalized with life imprisonment to death, it will be considered as reclusion perpetua to death. And the nomenclature of the penalties of the RPC will now be applied. Okay. So always remember this. What are the three kinds of felonies according to severity? Three kinds of felonies. We have grave felonies. Grave felonies. Examples: capital punishment and afflictive penalties. Capital punishment, we have death. For afflictive penalties, we have reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prison air. Then let's give felonies. We have here prison correctional, arresto mayor, suspension, and destierro. And for light felonies, we have arresto minor or a fine, and even public censure. Okay, so that will be all. Thank you for listening, and have a great weekend.